The murder conviction is reversed in the Kayla Giles case. We're going to bring you all the way up to speed on the saga thus far and tell you what's next in this exciting case. Stay tuned. This is attorney Andy Marcantel and attorney Marc J. Victor. We're the partners of the Attorneys for Freedom law firm here today to talk about the next chapter in a very exciting saga. How you doing today, Marc?
Dude, it's another awesome day to be on the planet, especially when we have such good news to bring to people.
Yes, absolutely. This is excellent news. But maybe some people are just tuning into this story. They don't know the background, as I've been calling it, the saga of Kayla Giles. It really is a very interesting, crazy story with all kinds of twists and turns. I think we just need to start by bringing people up to speed on this case. Maybe we just start about how we found out about it.
Yeah, let's do it. So we didn't know anything about who Kayla Giles was at the beginning. We just were doing our thing, promoting attorneys on retainer. And a client of ours sent an email to me saying, hey, you should find out about this Kayla Giles situation. So we started looking into it.
That's right. It was just an AOR member that contacted us.
Yeah.
And notably, they said that, this person was a member of a competing organization, the United States Concealed Carry Association, USCCA. She was a platinum member. She was charged with murder of her husband. And for whatever reason, they dropped coverage of her. So you guys should look into that. The internet's kind of talking about it. So you and I were curious, and we started investigating.
Yeah, it sounded kind of unbelievable that USCCA had a member who I guess was a platinum member, somebody who had paid additional money to get additional benefits from USCCA, was involved in a self-defense incident and was just dropped. It just didn't sound right to me. So we tracked down the source. We went right to the lawyer who was representing Kayla Giles. Remember that? We had a conversation with him.
Yeah, this is pretty typical. Even when we take over a case that's maybe already in progress, or, if we just want to get the scoop of what's going on, this is very typical in the legal world. You call the lawyer. Other lawyers have called us to get information about high-profile cases that we've had, and if we have permission to talk about it, we do. And so we spoke to her actual lawyer that was hired by the USCCA.
Yeah, he was very receptive to the conversation, but didn't shed a lot of light on why she was dropped. You and I both talked to him. He specifically said, yes, I've handled other cases for USCCA. They contacted me. They said they had a member who was involved in a shooting. Seems like a pretty serious case. She was charged with a murder charge. He said, I got the file. I reviewed it. His exact words to us were that this is one of the most defensible self-defense cases I've ever had in my career. Keep in mind, this isn't a new lawyer. This guy was practicing longer than me. I was about 30 years or so at the time into the practice of law. He had been practicing 40 years, criminal defense the entire time. This guy's been around the block. And he said this was a great self-defense case. I said, well, why did they drop it? He says, I have absolutely no idea. They paid me $50,000 to get started on the case. I had to give them the information about the case. That's one of the requirements, right? So the lawyer that they hire has to provide information, police reports, witness statements to, I don't want to say the USCCA because they don't really make the decision. They have an insurance company. And apparently someone at the insurance company said, you know what? We changed our mind. We don't want to cover this person. And they pulled the rug right out from under him. And they said, we're not sending you any more money. You're done. We are going to drop her as a member of USCCA. We're still going to drop her. We've decided in our judgment that this is, as they said, first-degree murder.
Right.
Premeditated first-degree murder, not an act of self-defense.
Yeah, we'll get to their statements in a minute, but the timing here is really interesting, right? It was before a conviction. She didn't plead guilty. The case ultimately went to trial, but this was well before trial that they made this decision. This really bothered us because you and I are really, really passionate about the presumption of innocence in this country. She was presumed innocent at the time that they pulled coverage.
Now
that was offensive to us.
It's even worse than that, Andy, if you remember, because he said, wait a second, he tried to fight the fight and said, look, I just got the statements of her daughter, who made a very clear statement. You and I made a video about this particular statement that the daughter made. She said, I was there. I was a witness. the person who was shot, which was in the process of divorcing, the MMA fighter who she was in the process of divorcing, they had a horrible divorce, lots of domestic violence in it. He actually went to the car door, opened the door, and then jumped at her. She said it many times. So he had that statement. He hadn't yet provided it to the insurance company for USCC. He said, hold on a second. Let me give you this statement. I think this will change your mind. And he said they weren't interested. They didn't even want to review that statement, which really bolsters the argument for self-defense. They just weren't interested. He was kind of frustrated. He didn't know why they dropped the case, but he said that the money stopped and he couldn't represent her anymore. And that was that. And she was forced to go find a lawyer out of her pocket to pay to get some representation on the case.
So that was our conversation with the lawyer. And, we took his word for it, but at the same time, trust but verify. So we kept digging. We wanted to do our due diligence to make sure that we had our minds wrapped around the entire story here. So we actually obtained a copy of the case file. We had the full court file, which we went through and started putting together all of the facts. The facts are pretty simple in this case. As you mentioned, we have a contentious divorce. There's a child custody battle going on, very, very nasty. And there's a couple of different things about both Kayla Giles and the deceased Mr. Cootie's background that I think are noteworthy here. Number one is that Mr. Cootie is an MMA fighter, as you mentioned, and he was known to start carrying a firearm to these custody exchanges in a way that Miss Giles found intimidating. Yeah. She's much, much smaller. I think she's like 5'1". He's over 6 feet tall. He's got
twice her weight,
easily 100 pounds on her. And so she found this intimidating. And so the evidence presented at trial that's in the court file shows she started researching things on the internet, things that the prosecutor would later claim were incriminating. Things like, how do I shoot somebody and be legally safe or something like that? And then she started looking up self-defense insurance because, she wanted to be sure to get self-defense insurance before some kind of a planned incident happened, according to the prosecutor. So shortly before this incident happened, she signed up for the United States Concealed Carry Association, became a platinum member. Also, another interesting fact is that there was a family court order that apparently was issued by a judge that would have prevented her from buying firearms. However, evidence tends to show it was not served on her at that point, so it was not legally valid or in place at the time. But for whatever reason, she went to Texas. She left her home state of Louisiana and purchased the firearm in Texas. It's not clear if she left to Texas for the purpose of buying the firearm, but our understanding and looking at the evidence, she was legally allowed to purchase the firearm. Some people made a big deal out of this fact. Oh, she crossed state lines. And, all the people who don't like red flag laws are saying, well, there was this order issued by the court, and so she shouldn't have been purchasing a firearm. Okay. Our reading of the evidence is that she was legally allowed to purchase the firearm because it wasn't served.
Yeah, that's right. And, there was a lot of evidence here about domestic violence in the relationship. There were allegations that the deceased punched her, knocked her out, slammed the car door on her leg. As you mentioned, was carrying a firearm to these custody exchanges. So, of course, she's in fear. She has good reason to be in fear from this person. They've got an ugly divorce. There's orders of protection flying against both of them. And so she does what any responsible person would do, get a firearm and then study the law, learn what you can do and what you can't do. And unfortunately for her, she didn't sign up as a member of AOR. She signed up as a member of USCCA because she was concerned she might be put in a situation where she might have to use her firearm. I mean, that's what everybody is thinking about when they join any of these programs, right? If you don't think that there's some chance you might be involved in a self-defense incident at some point, you don't need any of these programs. I mean, everybody is subject to this concern.
So that inference that you just drew, let's dwell on that for a second.
Right.
That's what a criminal defense attorney does right there. Like what the prosecutor did in this case and what USCCA would ultimately do, which we're going to talk about in a second, is draw the worst possible inference from the evidence. Oh, what she's doing is plotting a murder here. Our first reaction when we started looking at the evidence was we were like, this is exactly what you would do if you were worried about an imminent attack on you by a violent domestic violence situation out of a custody exchange with my husband who's beaten me before, who's now carrying a firearm and intimidating me. what would you do? You'd start researching self-defense laws and you'd sign up for coverage.
That's right. And it's a good thing she did, ultimately, or this story might be completely different.
Yeah, that's right. So that was our review of the case file, but we weren't done researching this case. We wanted to dive further. By the time that we had found out about the case, she had already lost at trial. That's when it really made the news. And so the case was up on appeal. You and I spoke to her appellate attorney.
That's right. We had a good conversation with the appellate attorney. She gave us her permission to talk to her client at the time, Kayla Giles. She went over the case with us. She went over the issues in the appellate brief. We did whatever we could to try to assist with that. There were some things to discuss there. We've done our share of appeals in criminal cases as well, so I hope we contributed something to her thinking in that process. But, I came away from that conversation feeling like she had a competent criminal defense lawyer representing her at that appellate case. And at this point, it was heading to the Supreme Court by the time we got involved. And so the next thing we did was talk to Kayla Giles herself.
That's right. And we recorded it. The very first conversation that we ever had with her was recorded. You guys can find the link in the description where we talked to her about the incident. We walked through the entire thing with her. We looked at this as part of our research. And you'll see us say in that video, we haven't reviewed everything yet. We're still in the process of reviewing. I think we took all the while we were learning about this story, a very conservative tact about drawing conclusions until we had all the facts.
Yeah, I think people who are familiar with how we do business here at the Attorneys for Freedom Law Firm, they know we don't just rush into making reckless conclusions. We don't make allegations that aren't supported by the facts. We try to take a very careful and balanced approach with everything we do. And again, as we presented everything, there was never any yelling and screaming or flying off the handle. We didn't know exactly what USCCA was thinking when they decided to drop her. So again, we went right to the source. I mean, I sat down and drafted what I thought was a very clear letter that I sent to Tim Schmidt himself over at the USCCA.
Yes, Tim Schmidt being the president and CEO of USCCA.
To ask him questions, essentially, why did you drop this case? We don't want to make allegations. We don't know what happened. We'd like your information. Tell us why you dropped the case. Maybe there's a good reason. Maybe she didn't pay the bill or something like that. That could have been a good explanation for why they dropped her. Had that been his explanation, we wouldn't have proceeded any further. Hey, you don't pay the bill. You're not a member anymore. You don't get the coverage. I don't know. I mean, why did you pay $50,000 to get started? Would have been a strange explanation, but there would have been some explanation. So I spent some time, drafted a fairly long letter. We made a video about that as well, and we should post that in the links as well so people can see the letter that we wrote to USCCA trying to get their rationale for dropping Kayla Giles as a member of their program.
Yes, and by the time that we had really started diving into this case and making videos about it, this was a huge controversy in the 2A community. A lot of people were really freaked out that, if I have USCCA's coverage and they just kind of arbitrarily decide that they can exclude me, is this going to happen to me in my time of need? And so we started researching USCCA's general response to this, and we were pretty shocked by what we saw. They had videos out there with Tim Schmidt saying that it was clear, and I mean perfectly clear, that a member had committed premeditated murder.
There was a time when it became very, very clear, and I mean perfectly clear, that a member had committed premeditated murder. In fact, after originally paying a $50,000 retainer to the attorneys of Kayla Giles, evidence including internet search history, witness testimony, attempts by Kayla to hide evidence, and surveillance footage was turned over that overwhelmingly demonstrated that this was an act of premeditated murder.
Which immediately, you and I had already reviewed the indictment at that point. It was actually a supervening indictment, meaning an updated indictment. So the final charges in the case, and absent from the indictment was premeditated first-degree murder.
Yeah, he came out and said it was so clear that his member, who he was now dragging through the mud publicly across the nation by publishing a video here, naming her, said it was clear that it was first-degree murder. She wasn't even charged with first-degree murder. Even the prosecutor didn't think it was premeditated first-degree murder because they charged second-degree murder, not first-degree murder. So none of this made any sense to us. I think it's important also to note, In none of our videos did we ever assert the position that she was innocent. We didn't make that kind of a judgment. None of this was about trying to figure out whether or not she was factually innocent or factually guilty of that charge. Our position had been then, as it is now, they shouldn't have dropped her.
Right.
I mean, we're in the same industry. It's clearly an arguable case of self-defense.
Clearly defensible.
Very defensible case of
Probably pretty damn close to factually innocent in my view.
Look, I wouldn't fault them had Kayla Giles got out of a car, walked into a bank, stuck a gun in a teller's face, said, get your money or your life, got a bunch of money and, tried to make a getaway, got caught, and then said, well, I acted in self-defense. Like, I wouldn't have faulted the USCCA for not covering that. There are times when I think it's proper to conclude this is not a matter of self-defense. But this wasn't even close to that situation. This was absolutely something that was well into the range of being covered. We absolutely would have covered her. Had she been a member of AOR, we would have been super excited about this case from the beginning. The thought of not covering her would never have crossed our minds.
Yeah, let me talk a little bit more, just one little nuance about the facts that I think is worth mentioning, because it was the basis of an entirely different charge in the indictment, which is there was an obstruction charge. Apparently, after she was arrested, she made some phone calls where she is alleged to have been telling people to hide evidence. Hey, go get the laptop, go get the bag with the thing in it. And the prosecutor made this out to be, look, she was trying to hide evidence that she was searching. How do you get away with shooting somebody and everything like that? So that ended up being a huge talking point for the prosecutor and a huge talking point for Tim Schmidt at USCCA. But after we analyzed all of this, after we did our due diligence, we reviewed the case file, we spoke to both of the attorneys, the trial level and the appellate, we reviewed USCCA's response. Our conclusion was this is extremely defensible, as you said, but also there's a lot of confusion about what's actually relevant here. Our view is this: the shooting itself was captured on video. The video shows Kayla walk into her car after the custody exchange and close the door. It shows Mr. Kuti walk up to the door. Looks like he's heated to me when he walks up to that door, and he yanks it open. Then about a second later, it shows her shoot him.
Well, at least see him fall back after being shot.
Right. It shows him fall back, presumably, and admittedly from Ms. Giles, it's because she shot him. Louisiana's stand your ground law applies here. Louisiana's stand your ground law says that if somebody is trying to make an entrance into your vehicle, you are allowed to shoot them. So all of this stuff, all of this background stuff about crossing state lines to get the gun and signing up for USCCA shortly before this happened and searching things online, it's all irrelevant. It's irrelevant to the analysis of self-defense, and it's irrelevant to the analysis of whether or not the presumption of reasonableness from Louisiana's stand your ground law applies in this case. And so when you and I saw it, the first question was, why is the public so confused? And why is USCCA so confused about what is legally relevant here? I guess the answer is because they're not lawyers. An insurance adjuster made this decision.
Yeah, you measure the issue of self-defense by what's going on at that time, right? And if people here are confused, understandably, about even what the law is in Louisiana, this is not a situation where she has to even say, I was in fear for my life or a serious physical injury, which is normally the argument when you use deadly physical force. Here, because it's an entrance into a vehicle, she has to believe that she's using deadly physical force to stop the continued entrance into that vehicle by Mr. Kuti. That's all that she needs to show here for self-defense to get a complete exoneration. Unfortunately, because of, I don't know if it's the lawyer that she hired or what, but that jury instruction never made it to the jury.
Right.
They weren't even informed that she benefits from a presumption of acting reasonably, and all she needs to do is be in fear that he's entering that vehicle, and she tries to repel that entrance by the use of deadly physical force. That's exactly what happened here.
Said another way, ever since we first educated ourselves about this case, you and I were asking the same question, which is, if this is premeditated or she planned this in some way, how did she get him to walk over to the car and open the door? What's the state's theory here? What's the evidence? Is she using mind control to get him to walk over and open the door? Maybe she gave him like an invitation. Hey, you should come. I'm going to walk over and close my door and you should come over shortly thereafter. Maybe evidence like that exists, but it sure as heck wasn't presented at trial. And so what ultimately happened here is the judge gave the jury an instruction that said basically, if you find that she's the aggressor at the time of the incident, then she doesn't get to claim self-defense. But like all jury instructions, it has to be based in the evidence. And there was no evidence that was presented that she caused him to come over to the car and open the door and trigger the Louisiana Stand Your Ground statute.
Yeah, and this isn't just our opinion. I think it's very important to know. This is the opinion of the Louisiana Supreme Court. And I'm going to read from this decision in a little bit, but they specifically found there is no evidence whatsoever to support an argument that Kayla Giles was the aggressor. And so when you tell the jury, hey, if you find she's the aggressor, you can completely ignore the argument for self-defense because you can't use self-defense if you're the aggressor. That jury instruction was erroneously given to the jury in this trial. It's no wonder she was convicted, right?
Let me try to drive home this point for people who don't understand the concept, the legal application of this Louisiana Stand Your Ground law here. Imagine the worst case scenario. Imagine she's at home plotting on a document that says how to kill my husband and plots out a first-degree murder, and they find that. The police find it, and they identify her handwriting and everything. They can clearly link it to her. Even if she did that, if he then walks over to her car unprovoked and unplanned and opens the door, Louisiana's Stand Your Ground law is triggered and she can respond in kind.
Yeah, so after all of that, and I felt really comfortable, and I still feel comfortable as I sit here today, that everything we did and everything we said was careful, was balanced, and was well supported in the law. I don't feel like we mistreated USCCA. We took every precaution. We literally asked them for their opinion. What response did we get?
Nothing. We gave them a few months after we sent that letter, but I wasn't expecting a response, honestly.
Yeah, the only response you could say we got was a video from Tim Schmidt entitled, "They Are Lying to You."
Yes, They Are Lying to You is a video that they put out in order to defend their decision to drop Kayla Giles and to basically tar and feather anybody in the 2A community who critiqued their decision to do so. Notably, if you are trying to pause this video right now to go search for it on YouTube, you'll find it's been removed from the internet by USCCA.
Yeah, strangely enough, it was removed right around the time that the oral arguments had come out from the Louisiana Supreme Court. And we started hearing some noises from those justices that they didn't feel like she got a fair trial here because of the jury instructions. So apparently someone at USCCA made the decision. And here, I don't know. I don't have any evidence here, but I think it's reasonable to conclude that someone at USCCA said maybe that video of Tim Schmidt tarring and feathering their own client, Kayla Giles, clearly stating that this was an absolute clear case of premeditated first-degree murder, and that's why they dropped her. Maybe that wasn't a good look for the USCCA, so they took the video down.
That's right, but we saved it, as did many other people, because we thought it was really notable, and we thought it was newsworthy. And we used that clip of Tim Schmidt on several of our videos and talked about it. And what they did was the USCCA didn't like that we used that video. And so rather than on defamation grounds or on truth grounds, they sent us a cease and desist on copyright grounds.
Yeah, keep in mind, this is a USCCA that tries to make the argument, look, they like free market competition, right? They're up for good competition. Let's put the products side by side. This is what Tim Schmidt himself said about free market competition.
Now look, I love competition. I love the free market. The USCCA intentionally makes our membership better every single year while our competitors continuously try to make a product that compares to ours. You know who wins in a situation like that? The marketplace, the end customer. Every one of us wins. But outright lying and complete intellectual dishonesty, those are the practices of cowards who cannot sell their product on its own merit.
Yeah, and that's all in the same video, in the "They're Lying to You" video. He was basically saying, look, it's not that we don't like competition on the marketplace. It's just that they're not telling you the full story or they're lying to you. And so, yeah, they've pulled that video off the internet. Whenever we have tried to embed that clip in our videos, they complain to YouTube about copyright strikes. Apparently, they don't care about fair use, but we think it's newsworthy. And it's true that they said this.
So let's show everybody the clip again right now.
There was a time when it became very, very clear, and I mean perfectly clear, that a member had committed premeditated murder.
All right, and so I'm sure we'll get another cease and desist from that, and from the reps over at USCCA. You can find our mailing address on our website, attorneysforfreedom.com. We'll look forward to seeing your new cease and desist, but notably, we've spoken to intellectual property lawyers, and we are very, very comfortable legally with our position to show this and analyze it, especially in the wake of the decision from the Louisiana Supreme Court.
But then the company USCCA that loves free market competition decided that wasn't enough to try to get us to just shut up. So they decided to send a cease and desist to almost all of our influencers to try to get them to shut up.
Yeah, our influencers that promote AOR, they thought this was a very newsworthy story as well. And so every time they spoke about it and showed that clip, they would receive a cease and desist from USCCA. Same kind of thing, copyright grounds.
Did they not know Dan over at Heavy Duty Country? Did they really think this was going to make him shut up? Everybody who knows Dan over at Heavy Duty Country knows this just bounced right off the guy, right? But I'm happy.
I think it fired him up more, honestly.
Absolutely. I'm happy to report none of our influencers gave up on AOR. None of them stopped talking about this. All of them are reporting on it, and it had zero effect on us and on any of our influencers. Their tactic to try to scare us into lawsuits brought by the USCCA bounced off everybody and will continue to bounce off everybody, because we haven't done anything wrong and we're not backing down.
Yeah, it's interesting because they pull the video and then they engage in what I believe was a campaign to try to scrub the internet of this video and any memory that they ever said these things or that it ever happened. And so they kind of engaged in this campaign of intimidation. Anybody who shared this video or reposted it or wanted to discuss this extremely newsworthy and factually true story about what they said about Kayla Giles would get the cease and desist and the intimidation tactics.
And it's too bad because they could have taken a different road here. They could have just said, oops, we made a mistake. We want to fix it. We want to cover Kayla Giles. I mean, they could still do that. I hope they do that. That's what they should do in this case. They should have done it back then. But it's not a crime to say, oops, I made a mistake. We made a bad judgment here. We want to fix it. I think people would have respected that much more. But instead, they went on this campaign to try to shut us up, try to shut our influencers up. Then there was the Connecticut issue.
Right. Okay. Yeah, this is kind of interesting. So around the time all of this is happening, we received a cease and desist letter from the insurance department in the state of Connecticut, who said, it's come to our attention that you guys are practicing insurance without a license with your attorneys on retainer program, and so therefore we want you to cease and desist. So that's a whole saga. You should definitely watch the video down in the description about the Connecticut story. We are so proud of how we rose to this challenge, overcame it, and did right by all of our clients in Connecticut. So definitely go check that out. But what's relevant to this story here, Mark, is that we started investigating. We wanted to know who filed this complaint against us.
Yeah, and while it was very clear that somebody filed a complaint with the insurance commissioner in Connecticut, we weren't able to actually tie it back to USCCA, but that certainly still leaves us wondering whether the USCCA was actually behind the Connecticut situation. But I think it's fair to say, and we should say, just so the record is clear, we continue to cover everybody in Connecticut. We are open for business in all 50 states, so even that was entirely ineffective.
But USCCA wasn't done yet. They rallied their influencers, the people who promote USCCA on their channels. Maybe you guys know a few of them. And they started simultaneously talking poorly about the attorneys on retainer and actually started defaming us.
That's right. Yeah. Marc is anti-Second Amendment. Marc believes this. Marc believes that. A whole bunch of garbage was spewed out by influencers who are being paid by the USCCA. So what did we do there? We set the record straight. We put out a very long video on exactly what our political views are. We put out a shorter video, about 10, 12 minutes, on exactly what my personal views are. And then I wrote a very long article about the particulars of my thoughts on the Second Amendment, which I am happy to defend. All of that you can find in links to this video if you're interested.
Yeah, it just seemed like as soon as we started talking about this, there was this massive coordinated campaign to discredit us and to hide that video, hide those statements, hide the trashing of Kayla Giles from the history of the internet. It's crazy that it's scrubbed as much as it was, but we're doing what we can to keep this story alive.
Needless to say, this is not how we do business, right? We operate based on high character, based on integrity, based on the idea that money, while it's important, I mean, I'm a proud capitalist, I'm an entrepreneur, money's important. It's not the most important thing. Freedom is more important than money. Integrity is more important than money. Acting with high character in everything that you do is more important than money at our operation, and it always will be. And I think people who are in AOR and have been for a long time, who watch how we do business, our clients who we've defended, the things we've done. I mean, look, our law firm is not new. We've been in business since 1997, continuously representing people in major felonies. Check out our Google reviews. How we do business is easy to figure out. How the USCCA does business, you make your own conclusions on that, but nothing we've said here is anything other than entirely factual, and it's in the record. That's why we're putting the links in this video for people to do the deep dive and go down the rabbit hole if they choose.
Yeah, like, for example, when they sent us a cease and desist in Connecticut, we had a couple of options, but a non-issue for us, a non-option for us is to not at all times do right by our clients. We had to do right by our clients, even if we weren't allowed to be paid for it. And so we made the decision as a company to represent every single one of our Connecticut clients pro bono for almost a year. It was almost, I think it was 10 months or something like that, for us to jump through all the bureaucratic red tape that the state wanted in order to get the risk retention group and upgrade the program and everything so that we could make sure to appease the insurance company. We're not going to make our clients pay for that, for the government bureaucracy. And so we proudly said, you can't stop us from representing them pro bono if we don't charge them any money, and that's what we did.
Yeah, I always say we're lawyers first, and we're proud lawyers. I mean, I think lawyers have done a lot. I know people defame lawyers and bust on lawyers and don't like lawyers. I'm a very proud lawyer. A lot of the founding fathers were lawyers. Lawyers have really led the charge for freedom in the history of the world, I would say. And so I think lawyers serve a very important role in a free society. And so we're going to do what honorable lawyers acting with high character would do in every single situation. That's exactly what we've done throughout this whole thing.
All right. So now that we're more or less up to speed on everything that's come up to this point, we got to get to the big news about Kayla Giles. But let's start with the December 2024 oral argument that happened in front of the Louisiana Supreme Court. This is where her appellate counsel had a chance to make an argument to the panel of justices at the Louisiana Supreme Court and brought up many different legal arguments. We did a full analysis video because ultimately the judges would side with her on the jury instruction issues, which we'll talk about in a moment. But to be fair, there were also lots of other really strong arguments in our view that were raised that the justices simply didn't reach in their ultimate decision. I definitely think it is worth it. If you're doing a deep dive into this subject, go and check out our analysis video of the oral argument at the Louisiana Supreme Court that occurred in December 2024, because there are a number of issues, in my view, that they could have sided with Kayla on.
Yeah, let's let everybody see some of those fun clips from those justices, which I think probably USCCA was paying quite a bit of attention to before they took their video down.
Somebody comes and opens my door of my vehicle, I may shoot them too.
In this
But we're
case,
talking about a legal question there, and that is the interrelation between the stand your ground law and the aggressor doctrine.
yes.
And if you are relying on the stand your ground law does the aggressor doctrine even come into play?
It shouldn't. It shouldn't unless there is evidence. A jury instruction should only be given if there's evidence presented at trial to support it.
It would be reasonable for a jury to believe that it's possible, if not likely, that Ms. Kuti did something or said something to bring on an altercation.
What evidence is there of provocation?
That's a
stretch.
Opening a door does not, one, make an entrance. That's simply the opening of a door.
Well,
That's another
my question is that, so you're saying that he can open the door and she has to wait till he gets in the car to shoot him under the stand the ground law, or can she defend herself if she's lawfully in a car, has a right to arm herself under the law, and he opens her door, and I can't think of any other reason to open the door except to get into the car, then at that point does she have the right to use the weapon?
Yeah, when that oral argument came down and we saw the reaction of the justices, you and I had a good feeling that our positions that we've had for years on this case, because we've been yapping about this case for a long time, it's all out there on the internet, the record is clear, we felt like we were going to be vindicated here. We're like, yes, they're finally going to stand up for Kayla. They're finally going to do what they're legally required to do. We felt pretty good after that oral argument.
Yeah, and there were a lot of issues that were raised here that the Supreme Court in Louisiana didn't even reach. There were questions about jurors and jurors who were left on the jury, who shouldn't have been left on the jury. There was a real question about whether trial counsel was ineffective in this case. They didn't have to reach those issues, but those are really serious issues all by themselves. But here, what they decided the case on really were two separate issues that, in my opinion, either one could have required reversal. One was a jury instruction that was given to the jury that should never have been given to the jury, which is the one we've already talked about, the aggressor doctrine. That's what they talk about in those oral arguments, this issue of, if you find that Kayla was the aggressor, forget about self-defense, it doesn't apply. Like, why give that instruction when, according to the Louisiana Supreme Court, there's absolutely no evidence that Kayla Giles was an aggressor at any time in this case?
Yeah, if you're analyzing a post-conviction relief issue regarding a improperly given jury instruction, it has to be supported by the evidence that was presented at trial. You can't just pick any jury instruction. You can't just tell the jury things arbitrarily during the instruction phase. It has to actually have been something that was supported. So they gave this instruction basically saying, hey, and if you find that she's the aggressor, the argument was there was no evidence that she was the aggressor. Think of it like this. Just as much evidence was presented that she was the aggressor in this case as that she committed tax fraud the year before. It would be as if the judge said at the end, and if you find that she cheated on her taxes last year, you can convict her of tax fraud. And if you find that she committed shoplifting last March, you could convict her of shoplifting. And if you find she stole a car, there's just as much evidence presented at trial of those allegations as there was that she was the aggressor.
Yeah, so that was a huge mistake, obviously. I don't know what was argued by the trial counsel, but to let that jury instruction go to the jury when there's no evidence that Kayla was the aggressor, maybe that's wrapped up into the ineffective assistance. And again, to be fair, I don't know exactly what that lawyer argued, if that lawyer argued against that instruction being given to the jury. But that issue itself is such a big issue that you can't say that she had a fair trial just because that aggressor doctrine instruction was given to the jury.
And I want to reiterate this point because this has been a sticking point for people thinking clearly about what the law requires in this case. Maybe you like the law, maybe you don't like the law, but this is how we analyze it as lawyers. Even if you presume that she planned everything ahead of time, even if you presume that it's true that she researched in an evil way how to kill her husband, all of that stuff is not being an aggressor in the situation. All that we care about is the fact that he walked over unprovoked, opened the door, and tried to make an entrance into the vehicle. That's all that matters here.
So the second issue here might even be a bigger problem than wrongfully, inappropriately giving the aggressor doctrine instruction. The second issue is a function of the fact that Kayla Giles was entitled to what we lawyers call a presumption of reasonableness. And remember, reasonableness is the whole ball of wax in a self-defense case. If you're acting reasonable, you win. You're acting appropriately, self-defense applies. If you're acting unreasonably, you lose, you go to prison.
Yeah, you guys hear us talk about this all the time when we're analyzing self-defense cases. Reasonableness is the whole ball game. There are lots of different contributing factors and elements that go into a reasonableness analysis, but at the end of the day, a self-defense case is both sides present all the evidence, the judge turns to the jury and says, what the defendant did, was it reasonable? And if the answer is yes, then they walk out. And if the answer is no, they're going to prison.
So under Louisiana law, Kayla Giles was legally entitled to a presumption of reasonableness. And the reason she's entitled to that is because under Louisiana law, if you are in your vehicle and somebody unlawfully opens and enters your vehicle, you get to use deadly physical force to stop that person from entering that vehicle. And you are presumed in the process of doing so, you are presumed to be acting reasonably. Can you imagine? The jury was not instructed on that aspect of Louisiana law at Kayla Giles's trial. It's possible trial counsel asked for that instruction and the judge said, no, I'm not giving it, in which case it wouldn't be ineffective, but we don't know yet because really, even though that's an issue that was raised to the Louisiana Supreme Court, they didn't reach that issue. That's still out there lingering, right? Even if this didn't get reversed on appeal, which it did, she could still have brought that ineffective assistance of counsel argument to say, look, this was a real mistake. My lawyer should have asked for that jury instruction, but she didn't have to because the Louisiana Supreme Court said this is such a big deal. Essentially, what they said is we can't say she received a fair trial because such an important point of law was not presented to the jury in a jury instruction. She didn't get a fair trial here.
Let's set the stage for why this is so important, because a presumption is a legal term of art. It's a term that we as lawyers we want to fight for that presumption.
Yeah.
If we get that presumption, it's so powerful for our client. Here's what it looks like just in practice. Imagine you're sitting in the jury box and you've heard all the evidence in the case. And then at the end of the case, while reading you the instructions before it's time to go off and deliberate with your fellow jurors, the judge turns to you and says, and ladies and gentlemen, Miss Giles, in her actions in this case, she is presumed to be reasonable. She is presumed to be reasonable. Not I want you. You are required to start with the presumption that what she did was completely reasonable.
Yeah, I mean, it's a rebuttable presumption, which means that the state has the option to try to rebut that presumption by saying, no, she wasn't acting to stop him from coming into that car. I mean, that's a pretty difficult argument where, as one of the justices on the Louisiana Supreme Court said, the whole thing's on video. You can literally see him open the door and opening the door by itself is entering the vehicle. I mean, do we have to wait for the 1 second before he puts his hand around her throat? No. I would argue that as soon as somebody opens your car door without permission, they have entered your vehicle and you get the benefit of this presumption. That's exactly what the Louisiana Supreme Court found. That's why they said this second-degree murder conviction cannot stand.
Yeah, compare the jury instruction that I just gave to the hypothetical juror to what was actually given at Kayla Giles's trial, which is, oh, yeah, and by the way, if you find that she's the aggressor, then you can throw self-defense out the window. I mean, those two different admonitions from the court are going to have two completely different effects. The Louisiana Supreme Court has now recognized that.
With these errors, it's easy to understand how somebody in Kayla Giles' situation, right, seems like a pretty clear case of self-defense. Not just defensible, seems like a really solid case of self-defense. You can see with both of these erroneous instructions, one given that shouldn't have been given, another that should have been given that wasn't given, why the jury convicted Kayla Giles on second-degree murder. But now it's fixed because the Louisiana Supreme Court did its job.
So what might be fun right now, we've highlighted a few different excerpts that we thought were really powerful from the Louisiana Supreme Court's opinion. Why don't we go through a few?
So the actual opinion is really long. That's because there are justices who write concurring opinions and justices who write dissenting opinions. But the majority opinion's only 8 pages long, and I think it's worth a read, and I think it's worth looking at some of what they said here. So turning to page 2 of that opinion, let me read from the opinion. Here's what it says. A person using force in response to entry or attempted entry into their dwelling or vehicle need not believe she is in danger of losing her life. Rather, she need only reasonably believe the use of deadly force is necessary to prevent an intruder's unlawful entry or to compel an intruder to leave a protected place.
So that's not obvious to most people, right? You would assume that in order to use deadly physical force, you have to believe at all times that your life is actually in danger. That is just not what the law requires under Louisiana's Stand Your Ground statute.
Yeah, that's why you need to look at the law very carefully. And when we speak generally, we say, look, if you want to use deadly physical force, you got to be in an imminent fear of death or serious physical injury. That's generally the rule. But the rule is a little bit different if you are in your vehicle or you are in your home, essentially. And in Louisiana, what I just read was very clear. You don't have to think that Kayla Giles was in fear of death or serious physical injury, even though there's a very good argument for that. She just has to be concerned about somebody entering her vehicle and acting to prevent that entry. I think that's pretty clear under these facts.
No doubt.
Okay, turning to page 3 of that opinion, here's what it says. In an A4A stand your ground scenario, as defendant claims existed here, Louisiana Revised Statute 1420, subsection B, creates a legal presumption that a person lawfully inside the dwelling, place of business, or motor vehicle held a reasonable belief that the use of deadly force was necessary to prevent unlawful entry thereto, or to compel an unlawful intruder to leave the dwelling, place of business, or motor vehicle when the conflict began, if both of the following occur. 1, the person against whom deadly force was used was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered the dwelling, place of business, or motor vehicle. And number 2, the person who used deadly force knew or had reason to believe that an unlawful and forcible entry was occurring or had occurred. The remaining portions of the justifiable homicide statute provide that C, a person who is not engaged in unlawful activity and who is in a place where he or she has a right to be shall have no duty to retreat before using deadly force as provided for in this section and may stand his or her ground and meet force with force. D, no finder of fact shall be permitted to consider the possibility of retreat as a factor in determining whether or not the person who used deadly force had a reasonable belief that deadly force was reasonable and apparently necessary to prevent a violent or forcible entry involving life or great bodily harm, or to prevent the unlawful entry. Louisiana Revised Statute 1420, Section C and D. The statutory language, and this is the Supreme Court now speaking, the statutory language is blunt, strong, and clear. Boom.
Absolutely. And so the only arguable point here for the prosecutor might be, well, simply opening the door isn't making an unlawful entry into the vehicle. Well, you saw how the justices took that argument from the clips that we showed a little bit earlier. Of course, it's making an unlawful entry to yank somebody's door open when you're not invited to do so.
Yeah, and this statute is a very nice example of not only do you not have a duty to retreat, but the jury isn't even allowed to consider whether or not you could have retreated. So it's sort of a hard stand your ground state. I think it's the right law. And certainly, as the Supreme Court said, the language is blunt, strong, and clear. Too bad the jury never got to hear it.
No kidding.
There's a little section on page 4 that I think is important to read, so I'm going to read that right now. The defendant had sought a protective order against Thomas, and there was evidence of domestic abuse in their relationship. Okay, that's what the Supreme Court is finding as a fact here. very relevant to her state of mind.
Let me make a side note here, because while it wasn't addressed in this opinion because they ultimately turned on the jury instruction issue, there was a very good argument, in my view, made in the appellate brief that was argued at the Louisiana Supreme Court that it was ineffective assistance of counsel for the defense attorney, the one that she had to hire after she was dropped by USCCA, to not bring in an expert to explain domestic violence abuse and the mentality of an abuse victim to the jury. That would have been really helpful for them to know.
Such a huge point here, Andy. I'm glad you brought it up because, this is one of the first things you think about in a case like this, right? You try to put them in the shoes, not just of a reasonable person, but a reasonable person who has suffered and been the victim of domestic abuse. And sometimes, you might say things, right? I want to kill him or something like that because you have suffered domestic violence in your relationship. And that expert, which I think any reasonable, effective criminal defense attorney would have certainly brought into the case to testify in front of the jury, was never brought. That was a very strong issue, in my view, for ineffective assistance of counsel. But the Louisiana Supreme Court didn't reach that because they didn't need to, because they reversed the murder conviction. But it's a very strong point. It also shows why it's important to get a real defense. You got to be funded properly. You got to have the right lawyer who's got the right resources to bring the right experts to bear. Otherwise, you get convicted on a second-degree murder case when you had a very strong self-defense argument at trial.
Yeah. And I'll just flag a little important side point here, since we're mentioning other arguments that were brought up in the appellate brief that weren't ultimately reached. This is very common for a higher level court, an appellate court or a Supreme Court, to pick the issue that resolves the case for them and without reaching the other ones, then reverse the conviction. So they are not saying, by saying that the jury instructions are dispositive and the ones that they're going with, they're not saying that the domestic violence expert issue is not a valid argument. They're simply saying we're not going to reach that because we've already resolved the issue.
Yeah, what's pretty clear from our vantage point at this point in time is she didn't get a good defense in this case, and I think everybody's seeing that now. Okay, so there's some excellent language on page 5 that I think really illustrates, gets you into the mind of what the justices at the Louisiana Supreme Court, at least a majority of them, were thinking. So I want to read that right now. Here's what it says. Quote, defendant also relies on her statement after the shooting, which was played for the jury, in which she said she bought the gun to defend herself, got a self-defense insurance policy to be a responsible gun owner, and pulled the trigger only because she was afraid. She also cites testimony from Thomas's mother, Kathy Pearson, that she knew Thomas to carry a weapon, and from defendant's sister that she saw Thomas with a weapon when he picked up his daughter on a prior occasion. According to defendant, her statement after the shooting was consistent with what her 7-year-old daughter from a prior relationship told CAC interviewers and what the surveillance video from a neighboring Sonic restaurant shows transpired. In particular, defendant describes the shooting as happening after she was already inside the car with the door shut, ready to drive away. She says Thomas returned and, quote, jerked, end quote, her door open. Within seconds, defendant fired her gun at him. She claims this act was out of fear and to prevent entry into her vehicle, end quote. This is really powerful evidence here. And, people who are interested in the statement from the 7-year-old daughter, we did a whole video on this. She said it repeatedly. She was right there. She saw the incident. Of course, she was worked on years later when the matter finally went to trial. She said something a little bit different. She backed off on that statement by the time she got on the stand at trial. But her statement, which was made, I believe, the day of the incident,
Same day,
said many times, maybe 5 or 6 times. We went through it in the video. I read every single instance of it. He came over and jerked the car and jumped at her. I think she had said 1 or 2 times. It was very clear this was a case of self-defense.
Yeah, I don't know if this is the video you're referring to. We'll make sure to link everything in the description so that people can do their research. But I remember this was a huge point in the video that we did with our use of force expert, Jeffrey Hines. We had him in. We had him just take a look at the case, as we oftentimes do with all of our cases. We did it with Kayla's case, where we send it over to our expert and say, chop it up, take a look at it, go through it line by line, and then let's have a discussion about it. We just happened to turn on the cameras when we had that discussion with Dr. Hines. And to him, this statement from the daughter, preserved the day of the incident, changed conveniently for trial, was very important.
Yeah, for the voices out there who have tried to make the case that we have been reckless or somehow distorted the facts, it's not just our opinion. It's also the opinion of a well-recognized, highly experienced use of force expert, Jeffrey Hines. He looked at this and thought this was a very strong case of self-defense. People who are looking at it closely, including the Louisiana Supreme Court, now are seeing this was definitely, was it arguably self-defense such that USCCA should have covered her? I think we're well into that.
We're well past that.
We're well past that. Continuing on page 5 of the case, there's some more language here I think that's very interesting. Here's what the Supreme Court said, quote, Thomas was an amateur MMA fighter, 6 feet tall to her 5'1", and nearly twice her weight. According to defendant's statement, Thomas had knocked her out on a prior occasion and had been harassing her in recent months. In addition, defendant's sister testified that Thomas had been violent in the past and that defendant was fearful in the weeks before the shooting. Continuing on, it did not properly apply, and they're talking about the Court of Appeals, it did not properly apply Louisiana Revised Statute 1420B's directive that this defendant benefits from a legal presumption that she held a, quote, reasonable belief that the use of deadly force was necessary to prevent unlawful entry thereto or to compel an unlawful intruder to leave, end quote.
Super powerful.
The trial court also instructed the jury on the aggressor doctrine by advising a person who is the aggressor or who brings on a difficulty cannot claim the right of self-defense unless she withdraws from the conflict in good faith and is in such a manner that her adversary knows or should know that she desires to withdraw and discontinue the conflict. Okay, so there you've seen they made both of those 2 points. Number one, absolutely this jury should have been instructed about what they call the directive of the presumption of reasonableness. And then mistake number 2, a person who is the aggressor. That's how this jury instruction starts out. A person who is the aggressor or brings on the difficulty cannot claim the right of self-defense.
Yeah, so basically what they just did, remember earlier when I told you those 2 hypothetical jury instructions? They just laid it out really clearly here. This case is simple on the issue that they ruled on, which is there was a really, really strong jury instruction for Kayla that she was supposed to get, but she didn't get. And then there was a really bad, inappropriate jury instruction that she was not supposed to have, but she did get that jury instruction. So in a nutshell, she was screwed.
And this is essentially what they're saying on page 6 of the opinion. Continuing on with the Supreme Court's majority opinion, quote, this analysis imports concepts that turn the express statutory provisions of Louisiana Revised Statute 1420B through D on their head. They continue on another line later, quote, the appellate court's approach seriously undermines both our state's stand your ground laws and our citizens' Second Amendment rights. The bottom of page 6, they continue, the aggressor doctrine charge, when there was no evidence she was the aggressor, materially conflicts with the provisions of Louisiana Revised Statute 1420, end quote. Did they just proclaim the aggressor doctrine charge when there was no evidence she was the aggressor? I think this is fascinating.
Yes.
And really important to understand this case. The Supreme Court of Louisiana just made a finding that there was no evidence that Kayla Giles was the aggressor.
What more do you have to say? And if you're not the aggressor and the aggressor doctrine doesn't apply, you are presumed to be reasonable under Louisiana law. That's the whole case right there.
Yeah. They kind of conclude up their opinion on page 7, quote, Court of Appeal found this charging error to be harmless. We disagree. The state bears the burden of proving beyond a reasonable doubt that the killing was not justified. Under these facts, defendant is allowed to benefit from the Louisiana Revised Statute 1420 presumption. In this context, the erroneous charge does not support a finding that the guilty verdict actually rendered in this trial was surely unattributable to the error. Then they cite a case. Therefore, the conviction of second-degree murder must be vacated.
Now, interestingly, they still had this obstruction charge that they had to deal with. We talked about it, the facts earlier. The accusations at trial was that after this happened, she directed her friends to hide the laptop and hide evidence that she was researching, and so the prosecutor charged with an obstruction of justice charge. Now, the Supreme Court, it's tough to figure out how to deal with this exactly because they've now vacated the underlying offense, yet there's this obstruction of justice charge. Our question is, okay, well, what are you obstructing? What charge are you trying to obscure evidence from if there is no underlying charge? And so that's the challenge that the Supreme Court tries to deal with here.
Well, when you look at the opinion, I think it's pretty clear the Louisiana Supreme Court is not very impressed with the obstruction of justice charge. If you just take a look at their opinion, start on page 7, here's what they say. However, the Court of Appeals opinion fails to analyze the defendant's assignment of error, that the trial evidence was insufficient for her obstruction of justice conviction. It makes no mention of this assignment of error at all and does not reach a conclusion on it. Continuing on page 8, I think there's some very important language here. Here's what it says. The acts of this defendant consist of giving her personal laptop to her sister and later instructing her sister to give it to a friend. If this conviction is affirmed on remand, Court of Appeal is also instructed to reconsider the assignment of error that the 30-year sentence was excessive.
That's great. So let's say something about that. I loved this part of the opinion because it's kind of a 1-2 punch as far as I see it, Mark. They say, all right, Court of Appeals, first of all, we want you to analyze, can this conviction for obstruction of justice even stand in the first place given the horrendous errors that occurred here?
Yeah, I mean, they lay out the evidence. Here's what they say on that. The acts of this defendant consist of, number 1, giving her personal laptop to her sister, and then number 2, later instructing her sister to give it to a friend. Those are the only 2 facts that they lay out for the obstruction of justice conviction. I think we can read into that and conclude from that the Louisiana Supreme Court probably doesn't see enough facts here to support an obstruction of justice conviction.
But then they go on to say, even if, Court of Appeal, you find that this is enough to support an obstruction charge, 30 years? Really? We have something called the Eighth Amendment in this country. It's a prohibition against cruel and unusual punishment. They seem to be ringing that bell here in their admonition to the Court of Appeals that 30 years, which is more than a lot of people get for homicide charges in and of itself, might be a little bit excessive for asking somebody to move a laptop bag.
You know, Andy, I've been representing clients in major felony cases since 1994, and I've done a lot of obstruction of justice cases. 30 years on obstruction of justice is just unheard of. I spoke to Joey Hamby about this, one of the other lawyers at our firm, who's been practicing just as long as I have. He also feels the same way. 30 years for obstruction of justice? I think that's exactly what was in the heads of the justices at the Louisiana Supreme Court. I think first what they're saying is this is all you got for obstruction of justice, but even if you think that's enough, we're directing you to review whether 30 years is an appropriate sentence on an obstruction of justice conviction. I think that's a very clear mandate. It's a clear message to the judges on the Court of Appeals.
They're kind of slapping them around a little bit here.
You better take a look at this to figure out if this is even an obstruction of justice. And if it is, 30 years?
Yeah.
Seriously?
Give me a break.
Because even if they find that this is okay. You know where it goes next. It goes right back to the same Supreme Court. So be interesting to see what happens with that obstruction of justice.
It's outrageous, frankly. Kayla was just crucified in this case. She was thrown to the wolves. She was crucified in the press. She was tarred and feathered by the company that she was supposed to be relying on
to protect her.
This judge, the trial judge, clearly had the attitude that, well, let's just ship her up the river. Let's give her 30 years. She's already going away for murder. So let's just give 30 years for the obstruction charge, throw away the key. And the Court of Appeals affirmed it, saying, well, there might have been some error, but it could be harmless error. Thank goodness that the Louisiana Supreme Court stepped up and did the right thing here.
Yeah. They also left us with a lingering thought here. It's kind of what we talked about before on page 8. They say, finally, defendant maintains the trial court erred when it denied her motion for new trial, which rested in part on her argument that counsel rendered ineffective assistance by failing to consult an expert in intimate partner violence. Given our findings above, we need not consider defendant's ineffective assistance of counsel claim. All right, so look, what they're saying there is, look, we know it's out there. There's still an argument that the trial counsel really screwed up this case by not bringing in an expert on domestic violence to sort of explain some of the things she did and said during the course of this case and before the case happened, to try to help people understand why somebody who's been a victim of domestic violence over a long period of time might say such things or do such things. That wasn't done. They're kind of reminding us that even at the end of the day, still an ineffective assistance of counsel argument here that is not going to be considered because they've reversed the conviction. And so I think it's important to note, to kind of maybe end up where we started, she didn't get a fair trial here. What's even more clear is that USCCA should have defended her.
No doubt.
That statement by Tim Schmidt, that this became absolutely clear, a case of premeditated first-degree murder, flat wrong. This is why bean counters over at the insurance company shouldn't be making coverage decisions on these types of cases. That's why in the Attorneys on Retainer program, you know who makes the decision? It's us. We make the decision about whether or not there's an arguable case of self-defense, which in our judgment just means if you can get a self-defense jury instruction. This one was entitled to lots of self-defense jury instructions that weren't even provided. Very, very happy that her case got reversed.
Yes, so let's talk about what's next for Kayla Giles. So the Louisiana Supreme Court has vacated her murder conviction, and it's going to be remanded down to the trial court for a new trial. Now, I'll flag something here. There is a possibility, I don't think it's a huge possibility, but it's a possibility that the Attorney General's office in Louisiana takes a look at this thing and says, oh, gee, she is now entitled, says our Supreme Court, to a presumption of reasonableness. Oh, man, this might be a big public loss if we were to take this thing. So they might say no thanks, but we think it's likely there's going to be a new trial.
Yeah, so I'm very happy to say that I've spoken with Kayla Giles, and she, of course, is very excited about the court's opinion, but she's also very excited to have the Attorneys for Freedom on her side. We've been making some noises about this from the beginning, about how much we've wanted to represent her. She's made it very clear she wants our team. She wants the only team, the Attorneys for Freedom law firm, the only law firm in the entire nation that does nothing but these exact kind of cases. I've told her we're happy to represent her in this case, and we expect to be filing a notice of appearance, entering our appearance in this case very soon.
Yeah, the record is clear. We have believed in her case for years, and we have been saying for years that this is an injustice, this is an outrage, and that we would be honored to represent her if the Louisiana Supreme Court did the right thing, and that's where we are, and we're going to be good on our word there. We're really excited to put our entire team of not only lawyers, but experts, not only self-defense experts and use of force experts. We're going to get a domestic violence expert. We're going to get all kinds of different mitigation type experts. There's going to be some really, really important defenses that weren't raised by her original trial counsel that we've already begun working on. Can't reveal too much. We got to save some traps for the prosecution, but we do expect to be putting in a notice of appearance as her counsel on this case.
Yeah, I wish I could convey how excited all the lawyers at the Attorneys for Freedom Law Firm and the paralegals who've been watching this case from the beginning. Our entire team is really pumped up to go in there and really clean up a mess. It's USCCA's mess. They should have done the right thing from the very beginning. Maybe they'll do the right thing now and say, you know what? It's time for us to maybe eat a little crow and say we made a mistake. Look, if I was in Tim Schmidt's shoes, I'd come out and make a video and say, you know what? I was wrong. I mean, it's not the end of the world to be wrong. Own your mistake. Say we made a mistake. We screwed up. We're going to cover this defense, pay for it, do what we should have done at the beginning, get the experts on board, and make sure that she gets the valid defense that she paid for when she joined the USCCA. But if they don't, or if they do, we're going to do our best to defend her either way.
Yes, so now the Louisiana Supreme Court says that there was no evidence whatsoever presented that she was the aggressor and that she is presumed reasonable in the shoot. I think that makes it pretty clear from my view that this should re-trigger her coverage with the USCCA. And USCCA says in their contract that their members get to choose their attorneys. Well, Kayla Giles has chosen the Attorneys for Freedom Law Firm. They've chosen our entire team. We're happy to take that case. We're honored to take our case. And so you guys should be paying for our representation.
So to Tim Schmidt, look, we're doing you a favor here. We're giving you another opportunity to fix it, to do the right thing. We'd be happy to come out with a video and say USCCA does the right thing by saying they were wrong in defending their member, what they should have done at the beginning. Do the right thing. We will be the very first ones to congratulate the USCCA for doing the right thing and fixing the mistake that they made. That's owning up. That's doing business the right way. Do the right thing. We're going to do the right thing no matter what you guys do.
All right. Now, I thought it would be fun to talk about what lessons we have learned. What can we learn as citizens from this case? And there are a number of different lessons that I think are worth talking about. Let's start very specifically when it comes to self-defense insurance. Exclusions matter. Exclusions matter. What do I mean by that? Well, if you research all of the different products in this industry, you'll find in their contracts that there are certain things they can immediately exclude you for from coverage. And there's all kinds of different ones. If you want to learn more about this, go to attorneysonretainer.us and check out the matrix chart page that we have, and you'll get to understand the types of exclusions that companies have. One of those exclusions is criminal acts. And if they decide that you committed a criminal act, in their judgment, they'll exclude you.
Yeah, it's a huge problem. A lot of these companies, people don't really research the contracts. This is what I did early on. I started reading from the contracts. People should look at the contracts because a criminal acts exclusion in the contract means that somebody over at the insurance company could just look and say, you know what? I think it's been a criminal act. We're dropping coverage. Again, do I have to point out that the Attorneys on Retainer program not only doesn't have a criminal acts exclusion, we specifically lay out in our contract that criminal acts are not excluded. We explicitly say that, but it's not just criminal acts. There's all kinds of other exclusions in many of our competitors' programs. Things like illegal weapons, things like sensitive areas. We've already had cases where people have had self-defense incidents in areas where firearms were prohibited, where other companies probably would have said, sorry, we're not going to cover you. But because we don't have any of these types of exclusions, domestic violence.
Oh, that would have been relevant here.
That would have been another one here. They could have turned it down and said, well, we think it's self-defense, but it arises out of domestic violence, therefore we're not covering it. They could have said that. They might still say that here for all we know.
If you're using alcohol or drugs at the time, if there's something wrong with the weapon or you're a prohibited possessor, or your CCW permit is expired, there's all kinds of different exclusions.
Yeah, we don't have any of those. A quick look at the Attorneys on Retainer contract, and you will see that we specifically list out all of those issues and say they are not excluded. So if you want to feel comfortable that if you're in a situation like this, you're not going to be dropped, that's the reason why the Attorneys on Retainer program is growing so fast and furious.
But here's another really, really important part, Mark. It's not just what the contract says. It's not just what the exclusions are. Who decides is really, really important. Who decides whether or not you're excluded? Who interprets the contract? I mean, that's really the most important thing. Just like we talk about on our show all the time. It's not what the law says. It's what the person in the black robe says that the law says.
That's right.
Same exact thing here. The interpreter of the language of the contract is so important. And that's why when you get an insurance adjuster interpreting what a criminal act is and what guilty of a crime means and everything like that, you're going to get results like this one.
Yeah, we've made it very clear on many occasions that with the Attorneys on Retainer program, you know who decides. You're looking at them right now. The two of us make the decision about whether we're going to extend coverage on the case. And we're not confused about why people join Attorneys on Retainer. We're not confused about what would happen to our program if we wrongfully denied coverage to somebody like the USCCA did here to Kayla Giles.
Yeah, I always tell people because they're like, well, what stops you guys from excluding people like them? Like the USCCA did, and not only Kayla Giles, but other high-profile cases. Whenever a client talks to me or asks me that, because I like to talk to our clients when they call in, I always tell our staff, like, transfer them to me if they have another question. They're usually like, hey, I didn't expect to talk to you. But whenever I do, I say, I'll tell you what. I'll tell you where your complaint department is. It's with the USCCA. It's with CCW Safe. If you feel like we've wronged you, we've dropped your case unjustly, we've denied you coverage unjustly, you acted in valid self-defense and we didn't allow it. I know some people who would love to hear about that. Go talk to our buddies over at the USCCA. They would love that news.
That's right. And that's never going to happen because, we do business a certain way. And I think that's, again, why people like our program. We've built trust with people who are in our program.
Yeah, you could have the best coverage on paper in the world, and if the person interpreting the contract finds that you fit into an exclusion, it's worth nothing at all.
That's right.
This is why you want passionate criminal defense attorneys to analyze whether or not you're covered. We do this for a living. We've done this for years. It truly is our passion. You guys know if you've watched our channel, this is not just a job for us. We see this as a calling, an important calling, and an important role that we have to play as criminal defense attorneys in a free society. Our role is so important, and we take it so seriously. And so when we see an opportunity to hold the government to its burden and defend somebody, even against insurmountable odds, we rise to the challenge. There's a couple of interesting recent examples of this that I'll point to, Mark. We recently did a video on the Carmelo Anthony stabbing. And I remember we made the video just because a lot of people were asking us to make the video. It's like, oh, there's this big case. Do you guys think it's valid self-defense or not? And you and I looked at the video ahead of time and kind of read the police report, did our due diligence. And our conclusion before making the video is, this is really not that interesting of a case. It seems like a bad stabbing. This seems like self-defense does not apply here. The statements are really bad that were made. It just wasn't a whole lot of interest. Like some of the videos that we talk about, it's really nuanced, and there's some cool issues that we like to discuss and hash out. This wasn't necessarily one of those on first glance. So when we started making the video, we started analyzing it and kind of explaining, this is going to be a really tough case for the defense.
With our commentator hats on, as we often wear.
Absolutely. But then we got to my favorite part of the video. We put our advocate hats on and we said, all right, now that we've kind of laid out what the law says and everything, let's have some fun here, Mark.
What would we do?
Let's come up with some cool defenses here. And we started analyzing, and as we kind of bounced some ideas off each other in real time, I think we came up with some pretty strong potential lines of defense for Mr. Anthony. Now, interestingly, if you take a look in the comments of that video, our own crowd, the 2A community, the people who claim to really like self-defense and who want us to represent them if they're in a tough spot, were saying things like, I can't believe you guys are making arguments to defend such a horrendous act and everything. This is what we do. We're criminal defense attorneys. We're passionate criminal defense attorneys. And when we see a brain teaser like this, we get excited about it.
That's right. We started that analysis with, had Carmelo Anthony been an AOR member, would we represent him? And the answer, of course, was yes.
Absolutely.
Even in that one, which is not nearly as good of a self-defense case as Kayla Giles.
Not even close.
Not even close. Not only would we have defended him, we would have come up with some arguments. Of course, we had to stop short because we didn't get a chance to speak to him to know exactly what he would say in an attorney-client meeting. But even there, we're going to make our best efforts to defend our clients because it's what we do.
We had a high-profile victory recently in Portland, Oregon, a very, very anti-gun jurisdiction where we represented an AOR client who was an armed security guard who had to defend himself with a firearm and ended up shooting and killing his assailant. Well, we released the raw video and solicited the opinions of the internet, and a lot of people, even in the 2A crowd, the people who are supposed to be pro-self-defense and pro-gun and everything like that, thought that, and I respect people to have their own opinions, that's fine, but they thought that this guy was in the wrong, and they gave their reasons for thinking he was in the wrong, and we're saying, I can't believe you guys would defend him, he was in the wrong and everything like that. This is what we do. We get excited to defend and advocate for our clients. So I say all of this kind of stuff to illustrate a really important point. You don't want to have an insurance adjuster who has an incentive to disclaim you making the decision on your coverage. You want a couple of passionate criminal defense attorneys who actually like doing these cases to decide whether or not you are covered. Problems arise when you have non-lawyers making these decisions and talking about legal issues. This is how you get Tim Schmidt saying, oh yeah, this is a perfectly clear case of premeditated murder. This is how you get a company to disclaim a really good case of self-defense like they did with Kayla Giles. If you're putting non-lawyers to analyze these legal issues and make coverage decisions, you're going to get absurd results.
Yeah, I think that's what people mean when they say AOR is backed by a real law firm, the Attorneys for Freedom law firm. That's really what they mean, right? At the end of the day, you got to have trust with the people who join the program. And I hope over the years, this is what you and I have built up. Certainly, I mean, in the 30 years or so we've had our law firm, we built up a lot of trust locally, but now we're on the national scene and it takes time to build trust. And we recognize that. And that's the reason we have so many loyal AOR clients, because they trust our firm. They trust us to make the right decision. They trust us to go into court and fight as hard as we possibly can for them. I would tell everybody, we will fight for you exactly the way I would want somebody to fight for me if I was the defendant in the criminal case. That's always been our standard at this firm, and it continues to be our standard to this day. We go all out on every case. We fight for every single, as I say, sometimes it's like an NFL running back who's fighting for every inch of ground. That's how we fight for our clients.
Yeah. So stay tuned, everybody. This is some really exciting news, obviously. AOR is going to be jumping right in and getting involved. We are super excited to represent Miss Giles and try to seek the justice that, frankly, she was deprived of at every single stage of this case. Stay tuned. You know we're going to be bringing you updates. We're also going to be sending a public letter to the USCCA, kind of outlining everything that we've talked about today and giving them the opportunity to make good on their contract with Miss Giles. And so stay tuned for that.
So like we've told Kayla, we can't promise any particular outcome here. No lawyer can promise how a case is going to turn out. What we can promise and have promised is that we'll make our best efforts on this case. We've said from the very beginning, this is a defensible case. Doesn't mean necessarily we're going to get a not guilty. I don't know. If there's a way to get a not guilty, we'll find it and make it happen. But nobody knows what a jury would do with this case. This is probably a case you try 10 times and you get different results. I think it probably splits more. You get a not guilty, then you get a guilty, given the correct jury instructions, given a proper presentation at trial. But nobody knows for sure how a case is going to turn out. We don't even know if they're going to recharge this case as a second-degree murder case, knowing that she's going to get a real defense this time. This isn't going to be a pushover at trial. She's going to get a world-class defense. What happens after that is out of our control, but we damn sure will control the defense that she's going to get, and it's going to be the defense I would want if I was in her shoes.
Now, make sure to do your research, folks. You got to take a look at the contracts, and we make ours very, very public. As we said, we have a proud list of non-exclusions of coverage listed out in our contracts, but it's very, very important to know what you are signing up for and make sure to research us. Also, before you make that decision, I think it'd be valuable for you to learn about some of our real-world victories for attorneys on retainer clients. Keep in mind, we can't talk about all of our victories. And the reason is because as a client of our law firm, we respect your attorney-client privilege. But every now and then, we have an excellent high-profile victory where a client will sign a media release and allow us to talk about it. I'd invite you to take a look at the links in the description. You will see recent victories AOR had in Texas, in Florida, in New York, in a very anti-gun jurisdiction, and also in Portland, the one that we referenced earlier. Go and check those out, and more are coming. And if this is the defense you want, go and check out attorneysonretainer.us. Learn all about our self-defense program and what it can do for you and your family. If you want to learn more about our law firm, go and check out attorneysforfreedom.com and see how we defend people in the criminal justice system. Until next time, this has been attorneys Andy Marcantel and Marc J. Victor, signing out.
Peace.